First and foremost with you, Siddharth Luthra, and the objections that have been made. The government says that there are safeguards built in. As a lawyer, in your practical experience, do you think that there is a possibility of these provisions being misused? Siddharth Luthra.
I think when you allow a period of 40 days custody, police custody, you negate bail. You may bring in safeguards, but police custody is the antithesis of bail. Theoretically, yes, bail can be granted even while a person is in police custody, but that's not going to happen. So let me make two things clear. And I have, there are some places where this law has tried to bring in certain changes, let's say in the area of technology, electronic evidence, and keep one thing in mind. We keep calling them criminal laws. The Evidence Act applies both to civil trials and criminal trials. And perhaps that's the reason least amount of change or tweaking has been done in those. Coming back to what I was saying. The point is this: you've introduced UAPA, you've introduced organized crime, mob lynching, good idea. But the first two, let's talk about. These legislations, where in the specific laws which deal with these provisions, you have stringent requirements to be met before an investigation can be begun, before a charge sheet can be filed. At the same time, you also have twin conditions, restrictive conditions for bail. Now, which one do you expect the investigator to choose? And frankly, I think it's a misnomer. The NIA is empowered as on date only to investigate UAPA offences. It is not empowered to investigate these offences. That change will have to be brought. So I think while the second version of these bills, the laws that have come in, have brought about some improvement in the original avatars that they were in, but eventually we have to see. We're a liberty-oriented constitution. We believe in the rule of law. We have Articles 19, 20, 21, 22. The period of police custody, even in British times, used to be 24 hours. Okay. We increased it in 1973 to 15 days. In some cases, specialized crime like organized crime or money or terrorism, you said 30 days. Okay. Point is, now you made it for ordinary crime. So for a theft, you're going to give 40 days for copyright theft. Copyright violation, you're going to give 40 days. That's what the law permits. Let's get a response. I think those are some very pertinent points. Let's get a response from Justice Satish Chandra, who's a member of the panel. Justice Satish Chandra, there are some very clear apprehensions that have been expressed. One is the overriding powers that have been given to the police. What if the crime is not something of this kind of magnitude, and in such a situation will also 40 days of police custody be apt? Is a question that several are asking. And there's also the entire aspect of overlap of laws when it comes to terror, for instance, where you will now have UAPA, you will have in states such as Maharashtra where there's Makoka, and in the IPC as well. So who will be investigating and which law will be applied? All these remain grey areas.
That is true. The maximum period has been prescribed. That is 40 days is the maximum period. It may be less than that in a particular case or small cases. So, and after that, a magistrate can give the permission to continuity. But in these acts, if you will find, see the object of these acts, the paperless in the Evidence Act, paperless work is there. Electronic and technical evidences have been recorded. All records have been taken not to go there. Time-bound trial is there. See, now more than 5 crore cases are pending in Indian courts. In the criminal law, 2,000 cases are pending. Of the year of 2000, cases still pending in the High Court. I came from the High Court where the pendency is more than 1 million. So this is the object of this act. If you will see the CRPC, speedy trial, and this you can say the time-bound trial that is there. So all these objects will be seen. And question is about the misuse. It can be happened anywhere and even today. Yeah. If there this Arms Act is there, so the policeman will put.
But are there adequate safeguards? Remains a question. Siddharth Luthra wants to respond to you on that. Siddharth Luthra.
From 1860, every criminal procedure code, and I think we need to get our history right, has said day-to-day trials. The only state in this country that allows sessions trials to go day-to-day is Kerala. They list a date for day-to-day trials, and they do it. Every CRPC, 1860s, 1898, 1973, everyone said day-to-day trial. We don't have the infrastructure, we don't have the manpower, and I'm sorry to say, Justice Chandra, if criminal appeals in your High Court, death penalty, death appeals get listed after 25 years, then we really need to ask, it's a systemic issue. Law will remain paper till you have the infrastructure to deal with it.
Important point, Justice Chandra. Laws are ultimately going to remain on paper unless there is a solid, bricks and mortar infrastructure to actually tackle the huge pendency, which is the bigger problem.
No, see, in infrastructure about the Allahabad High Court, I can say 160 judges are there, but still pendency is still going on. Even in Supreme Court also, if you will see, the pendency is continuing.
Okay.
So whatever infrastructure you will provide, that is a different issue.
Okay.
But question is this: if law is simple and there is a will of the judges to do the justice fast, then it can be done.
Right. Let me quickly bring in the two policemen on the panel, since we're also talking about police custody. Two retired officers are with us. Yashovardhan Azad, how much do you buy this argument that enough safeguards in place, and B, that this is the need of the hour to simplify the laws to ensure that the process of justice delivery becomes that much faster? Mr. Azad.
You know, for the last 75 years, the only whipping boy, whether from the lawyers, the justices, or the politicians, is the police. In the last CRPC, there was supposed to be a police commissionerate for all towns above 10 lakhs. This is not there anymore. The government thinks that the police should not be allowed to take statements and get them signed. If the government itself does not believe the police, the people will also not believe the police. Where is the police having overriding powers, and where is it becoming a police state? I don't understand. I understand totally that the 40 days is not correct. It should be only 15 days. That should be the maximum. I totally agree with that. But the other issue, I welcome this bill. Act now. I welcome it because of the accent on technology, scientific aids, forensics, everything. But the important thing which Siddharth says is true. You see, instruments of the criminal justice system, unless they are reformed, how can you have it? Police reforms are never coming. Now, if the police is not, if the police registers a UAPA case where it should not be, where does the direction come from? It doesn't come from that police officer, it comes from above. What about the prison reforms? You won't give a SIP to a Stan Smith. Then comes the prosecution. You know, you have a Siddharth Luthra on the other side, or my friend Sajjay Hegde, and here we have a fourth-rate prosecutor. Who will win? And the judiciary. Lordships cannot curtail their plea. Lordships cannot, change their manners. You cannot say anything against the lordships. 4.5 crores. What are you going to do about it?
Absolutely. I think those are very pertinent points. I'm going to allow Vikram Singh to come in to quickly rebut that. Vikram Singh, the problem is not with the law per se, but really the role that those who control the policemen will. What about the orders that are going to come from up above to potentially misuse even these provisions which have now been reformed? Vikram Singh.
Madhav, we go to a larger question of police reforms, that the police work in an ecosystem. And that ecosystem has to be reinforced in a manner that all extraneous, frivolous, illegitimate recommendations and instructions do not reach the police officer in the field, but that is easier said than done. Government after government, I said government after government have come and gone, but police reforms seem to be going on forever. Nobody is going to touch police reforms with the barge pole because all the rotten politics start from the police chowkis and thanas. If they let go of the thana, the politics goes for a toss too. Therefore, it is easier said than done. And one last sentence, Madhavji. Yeah. We have talked of policemen giving more powers. Again, confession made before a police officer is not admissible, even if it is made before Yashovardhanji and me. Even though we may be DGPs, it is not admissible court.